Today we will be looking at the principles governing the law of negligence. The first question we have to ask is, what is negligence? If we consult a dictionary, the notion of negligence is defined as the failure to exercise a level of care that a reasonably prudent person in a similar situation would exercise. So when does liability arise under the tort of negligence? In line with this definition, under the tort of negligence, liability arises when a party fails to take reasonable care when carrying out an act and as a consequence causes injury to another. As we have seen, to establish negligence, it is necessary to establish 1. The existence of a duty of care, 2. The breach of the duty of care, 3. Loss, and 4. A causal link between the loss and the act causing the loss. So let's look at these 4 criteria more closely. The first is the existence of a duty of care. According to the decision of the UK House of Lords in Donoghue and Stevenson, there is a duty of care as regards all people not to harm their neighbours by their acts. So the first question to ask when bringing or defending an action in negligence is, who is my neighbour? The court defined the notion of neighbour as any person, who we will call Y, who is closely and directly affected by an act carried out by another person, who we will call X, and who consequently should have been in X's contemplation at the moment of committing the act. In other words, X owes a duty of care to persons that he should have in his reasonable contemplation when acting in a certain way. The scope of the duty of care extends to all people in society. However, it can vary with the circumstances of each situation. For example, a highly qualified specialist doctor may owe a greater duty of care to a patient than a non-specialist doctor called upon to act in a similar case, especially if that is in an emergency situation where no one has the time to prepare. The second criteria is the breach of the duty of care. Once the conditions for a duty of care are established between X and Y, the next question to ask is whether that duty has been breached. The test to see if the duty of care is breached is either subjective, that is, X knew that Y would be hurt by his or her act, or objective, i.e., that is, X should have reasonably been aware that Y would be injured by his or her act. Liability only exists for risk that can be reasonably foreseen. Thus, in one case, a woman injured in her garden by a cricket ball was considered to have no cause of action against the cricket club. Although she was clearly injured by the cricket ball, the court considered that the injury was not reasonably foreseeable, as cricket balls are not normally hit so far. The law seems to be saying that sometimes bad stuff happens, and it is not necessarily anybody's fault. The third criteria is loss. It is not enough to prove that someone is negligent. It is also necessary to show that the negligence resulted in loss to the plaintiff. Compensation is available for different types of loss, and some losses are more easily compensated than others. For example, damages for pure economic loss or for loss linked to emotional suffering are more difficult to recover than damages for physical injury. This is because such damages are difficult to quantify. The fourth criteria is that of factual and legal causation. If a party establishes the existence of a duty, that the duty has been breached and that loss occurred, then the final requirement is that the plaintiff must show is that the loss would not have occurred but for the defendant's breach of his or her duty of care. Moreover, even if the defendant's acts are at the origin of the loss, i.e., are at the cause of the harm, the loss must not be too remote from the defendant's acts, i.e., the defendant's act must be proximate to the loss. Once this 4-point test is satisfied, then the plaintiff may recover damages. In tort law, the plaintiff has a right to recover for the following damages: general damages, that is, unliquidated or unspecified damages linked to the general pain and suffering caused by the negligent act. Secondly, special damages, that is, quantifiable loss, for example, loss of wages, medical bills, etc. And thirdly, punitive damages. Although not available in all common law jurisdictions, in some common law jurisdictions, punitive damages are available where the court considers that the plaintiff's acts need to be punished so as to discourage similar behaviour in the future. When a court awards punitive damages, it is fulfilling a regulatory rather than a judicial role. Punitive damages are often awarded when the defendant clearly acted in total disregard of the plaintiff's welfare. For example, selling cigarettes to the public without any warning, where the manufacturer knew that the cigarettes they sold were a health threat. A form of punitive damages are available in the UK and are called exemplary damages. We hope you enjoyed this discussion of the area of negligence.